and Merry Christmas, Happy Holidays. I'm John Giardinelli. I'm Association Counsel, and this is the last rant of 2023. So we're going to cover a couple of areas like a potpourri today. We're going to talk about some things that happened last week. We're going to talk about some questions that came in last week, and then I'm going to follow it up, if we have time, with just a couple of the new laws that I think are significant. But if I don't get to that because of time, we'll probably do it again pretty soon, maybe even do a newsletter. So first of all, last week we had a legal panel. When I say last week, I'm doing this program on December the 19th. And last week on the 14th, we had a legal panel with one of the speakers was Steve Lerner, who is the Chief Deputy Commissioner of the Department of Real Estate and is in charge of all the legal affairs for that department. Steve's a great guy, brilliant lawyer. And what I wanted to tell you about, in case you didn't get a chance to see the program, is Steve kind of dove into all these, we were talking about all these lawsuits that are coming down against compensation and the multiple listing services and NAR, and the likely response from the Department of Real Estate. And he made some really good points. First of all, fiduciary duty is still fiduciary duty. The highest obligations that you have to your client aren't going to change. The duties to be honest with your client, to provide them with all the information that you have available to you is not going to change. But what may change are some of the approaches that we take to some of those issues. So for example, while you will still have a fiduciary duty, it will be incredibly important that you be accurate in discussing things like your compensation. As the compensation rules change, and I firmly believe that they will very, very soon, you're going to have a duty to simply explain to your client, look, this is the way I charge. This is what you're going to get for that, the value proposition. And that's going to be simply important. And we're going to guide you every step of the way. I've already talked to the leadership, and they're absolutely bound and determined to provide classes and programs and anything you need. Obviously, you're going to need to take advantage of all this, but you're going to have access to some great information, I think. The other thing that might change is sort of the standards of practice. Right now, some of you are using written broker representation agreements and are providing information about your companies and your personal means of being compensated. And that's going to become much more formalized as time goes on. I believe, and Steve believes, and so does the MLS attorney, that buyer broker compensation agreements will no longer become optional, but they'll be basically mandatory. Additionally, under both the Business and Professions Code and the Code of Ethics, there'll be requirements that you talk about your compensation, what you normally charge, and all of that. So that's going to be expanded. And we're going to go over that. Lori and I are talking about doing brown bags and all kinds of other programs. Sorry about that. Got to turn off my phone. We're going to be talking about all sorts of stuff in the first part of the year. So we did get a bunch of questions. So let me just tell you about some of the questions that came up during this panel that we weren't necessarily able to get to because, frankly, there were so many questions. One of the questions that came in is, do we foresee an increase in double ending and dual agency? And the response is possibly. Certainly, as buyer brokers have to negotiate their compensation and get written agreements, buyers may decide to go straight to the listing broker, and there may be some conduct that will lead to that. We don't want that to happen because, frankly, it's the opinion of a lot of people from both the legal and risk management side as well as from a service side. The dual agency is not in the best interest of the industry and particularly the clients. So we don't know We're going to track it. We'll keep you posted. The next question I thought was an excellent question, which is how do we convince a buyer that they should have their own agent? And the fact is that a fiduciary that represents both sides to any transaction, whether it's a lawyer, whether it's a realtor, how do you discharge that fiduciary duty fully if you're representing both sides? For example, if I'm a realtor and I'm representing both the buyer and the seller, how do I negotiate? Right? I can't negotiate against my client for my client. So I'm representing the seller, the buyer wants to negotiate the price. How do I do that fully and effectively? How do I represent the buyer correctly if there's a problem with the property and repairs, but also represent the seller property? So I think if you sit down, create a plan, put together all the different kinds of scenarios for why you're having your own separate independent representation is a good idea. And we're going to help you with that. We just did a newsletter on the value proposition. I think the idea that you're free to negotiate fully, you're knowledgeable about the market, about the local area, that you have access to a multiple listing service, that you know how to navigate. I think all of those things are going to be critical. We were asked, what do we think the appropriate length of a BRBC agreement should be, and when should it be signed? All of us agreed that it should be signed as soon as possible. Both Ed Zorn, the MLS attorney, who's also a broker, and myself believe that you should sign it if you possibly can, under most circumstances, before you start showing property. How long should it be? It depends on the circumstances. What is your buyer willing to tie themselves to you for? 2 weeks, 30 days, longer? That's really going to be your call. Does everybody need to have written policies? We were talking to the Department of Real Estate. If you ever get an inquiry regarding some conduct, it's going to be very, very important that you have written policies in place, whether it's about showings, about information sharing, about compensation. All of those things need to be included. Advertising, all of that needs to be included in the company's written policies, and because the Department of Real Estate is going to ask for them. How do you set your fees? That's going to be totally up to you. I'm working with some New York lawyers right now, and their fees flabbergast me. But then they're in New York, right? And so it just depends on where you are, how complex it is, what you think is fair for your level of experience, and all of the rest of that. Are there going to be some legal changes? Well, we can foresee that the legislature may act, and based on what's going on in Washington State and what's going on in Oregon, we won't be surprised if the California State Legislature makes buyer side representation agreements mandatory. So keep an eye on that. We'll keep you posted as those issues develop. And then the last question is really self-evident, which is it had to do with, how do we persuade? How do we talk? What do we say? And the answer is tell the truth. Whatever you and your broker or you and your company decide to do, and this came directly from the DRE, one thing they're not going to tolerate is a misrepresentation and misleading of a client. So it is critically important that you tell the truth in everything that you do, and then let the client decide. I had a question come in. Is CRMLS considering artificial intelligence? And yes, they are. They're going to be doing work with artificial intelligence in rule compliance. And so that is something that they are planning on doing. Then we had a question regarding the specific duties that a landlord has when representing a landlord, or that a property manager has when representing a landlord. And I'm going to cover that in the next rant because it really is a whole rant kind of a thing. All right, so you are in California. You are lucky enough to have a legislature that is very, very active. And as a result, you have 860 new laws that this legislature passed. And I'm certainly not going to cover all of them. I'm only going to cover a few of them. And so let me kind of go through some of these with you right now and tell you again, we're going to talk about just a few of 860. The legislature has instructed that the homeowner's guide to environmental hazards booklet be updated, but they didn't provide any time frame or money. So just know that probably sometime in 2024, you'll be told that there is a new booklet for disclosures in the environmental hazards booklet. On January the 1st, a new law will go into effect. So if you represent what are commonly referred to as flippers, a new law will go into effect that will expand disclosures. If the property is a residential unit, if the seller who is flipping the property acquired title within 18 months from the date of transfer, and if renovations or repairs were performed by a contractor, then you must make additional disclosures regarding room additions, structural modifications, and other repairs. Again, the law will be very expansive. The law does not go into effect on January the 1st. It goes into effect on July the 1st, and they will be making some changes to the transfer disclosure statement between now and July that will then need to be filled out if you are in the category known as a flipper. NHD statements will be modified, and those NHD statements will identify specific fire hazard zones and defensible space. CAR has announced that they will be modifying some of the sales transaction documents that will go into effect. So be aware of that, and we'll keep you posted on the changes as they take place. For those of you that do property management, on January the 1st, a new law will go into effect that if I am a disabled tenant and I live in a community where there is some form of rent control, I will be entitled, if a property becomes available, or excuse me, a unit becomes available on the main floor of the building, and I have a permanent disability, I will be entitled to move into that same or similar unit without an increase in rent on a right of first refusal. It's a complicated law. We're going to do a newsletter and we'll keep you posted. But if you have any questions, let us know, because it will now be the duty of a landlord, where possible, to accommodate a disabled tenant by allowing that tenant to move into a accessible first floor unit. There's going to be some changes in the way that you look at history. And if a tenant can establish that despite bad credit, they have the ability to pay, and this is primarily going to be geared toward people in government subsidized housing, such as Section 8, and then you're going to need to accommodate them. So you'll need to provide applicants who fail the credit test with reasonable time to respond and provide alternative evidence of their ability to pay the rent that you're asking. This falls under the rules in California that the source of income is not significant. The ability to pay is what is important. Going to be some changes to some rules. If your tenants have balconies and they have electric bikes or other type of transportation, mini bikes, micro mobility devices. They're going to be allowed to store them on the balcony with or without the rules that you have for that type of stuff. And again, we'll keep you posted. That law goes into effect on January the 1st. It's limited to certain kinds of buildings, and but it does allow for exterior, secure, long-term storage of these types of devices. Some cities have passed crime-free legislation, and the legislature has put some strict interpretation on that, so that a lot of cities, particularly, this arose out of a case out in Hesperia, where they tried to prevent criminals from renting apartments, and that fell in the face of California law regarding discrimination and disparate impact on certain classes of people. So that's going to be limited, and local governments are going to be restricted on how they can enforce that. On July the 1st, security deposits will be limited in most circumstances to 1 month. There will be exceptions for small landlords. These are landlords that have less than 3 units. In other words, 2 units or two buildings with not more than 4 total units. And then the security deposit will be for properties that are more than that. You'll end up with a 1 month instead of a 2-month security deposit. They're going to tighten up under the rent control law, the statewide rent control law, the ability to terminate a tenancy by owner or relationship move-in. They're going to require that there be specific time frames, specific proof that the property is in fact going to be occupied by a close family relationship, and so forth. So that's going to be taking place very, very soon, and you're going to need to keep an eye on that if you're planning on moving out a tenant in order to put in a person of close relationship, or yourself. The DRE is going to be required as of January the 1st to honor gender changes and licensee name changes to reflect gender identification. On January the 1st, listing agreements will now have a 2-year maximum limitation. This is to combat some practices that some realtors in other states are using to record listing agreements. You will not be allowed to do that. And we'll go over that law with you at the next brown bag in a little more detail. And then lastly, just want to make you aware that small claims will now go up to $12,500, so that if you have a security or a deposit dispute, let's say, for example, that the seller believes they're entitled to keep the deposit, the buyer believes they're entitled to get it back, that will now, if the deposit is $12,500 or less, you can now go to small claims court without availing yourself of mediation and or arbitration. So that's it for now. I wish you all the happiest of holiday seasons and a prosperous New Year's. Things are going to be very, very complicated come January the 1st. Lots of things are going to change, but you belong to an association that is absolutely dedicated to making sure that you keep up. We'll do the best we can, and to make your lives as comfortable as possible. So in the meantime, have a blessed holiday season, a Merry Christmas, and we wish you a prosperous New Year. Thank you very much.